Hello, my name is Jonathan Puckett. This is my video presentation for Computer Ethics CPSC 4733. I chose to do my presentation on patents, and more specifically, why I think software patents should not exist. As we've learned about intellectual properties recently and did hear a great presentation by a fellow student and had discussions around this topic the past few weeks, there seems to be a lot of interest in protecting intellectual property. I do believe that intellectual properties are essential for business and important to our overall economy. Although for this presentation, I'll be talking about why software patents specifically are not good for our economy. Over the past few years, patenting software has become a controversial topic. Some people think that patenting software encourages investment in software related research because they know their product will be protected. Some people think that patenting software slows innovation. As with most things in this world, there's a great debate as to what is the best viewpoint when it comes to patenting software. Based on the research that I've done in this class and the real world scenarios that I have saw play out in my lifetime, I have to agree with the people who think software patents slow innovation. For this reason, I'm against software patents. I know that major companies such as IBM, Google, and Apple would completely disagree with the notion that patenting software stifles innovation, because they are a big part of the tech world and make huge profits from these intellectual properties. And you may say that those major companies are the ones that are creating a big portion of the good jobs in our economy. As that may be true, but these few major companies be driving most of the innovation that occurs. In short, I say no, because they would ultimately be creating monopolies, and ethically speaking, I think giving more people an opportunity would be the best for everyone and the overall economy. What if we all worked together, or small developers were not pushed back by big business so much? Would that open up more opportunities and jobs for a lot more individuals? Maybe so, or maybe not. There are pros and cons of each side of ethical debate of patenting software, and for my presentation, I will provide 3 reasons as to why I think software patents should not exist and give one alternative option that everyone should consider. Before I go into the specifics of my presentation, let's review patents and provide background information on this topic. Patents have been around for a long time. Patents are a way to protect an invention or an original idea so that you have time to build it, market, and profit from it. Patents can be used to prevent other people from using, importing, or selling software. Without patents, you might invent something and then someone with more resources and money could come along, create your invention, and by the time you are ready to sell it, they already have the market cornered. For the United States, the purpose of patents is laid out in the Constitutional Clause, Article 1, Section 8, Clause 8, that gives Congress the power to promote the progress of science and useful arts by securing, for limited times, to authors and inventors the exclusive right to their respective writings and discoveries. The U.S. Patent Act gives Congress the ability to grant patents through the United States Patent and Trademark Office. To qualify for a patent, your software needs to be new, original, useful, and a non-obvious piece of code or function. Software patents are usually utility patents that have to qualify as a process, a machine, an article of manufacture, a composition of matter, or an improvement on an existing utility. Limitations of copyright law, which is a whole different topic of concern, have pushed many developers to seek patents for their software. And because of this, software developers and companies are using patents to protect their software on a more frequent basis. So, how do you get a patent? This takes me to my first reason on why I think software patents should not exist. That is the patent process itself. Running a preliminary patent search and having the need of a patent attorney to make sure your new program does not violate anyone's software patent is very costly and time-consuming. As a result, only very large companies with big budgets can afford to run such a search. This effectively eliminates many small software companies, stifling competition and decreasing the variety of programs available to the society. Also, software patents take an average of 2.5 years to be granted, and the total cost of attaining a patent can be well over $10,000. And in software industries, product life cycles can be very short. So by the time all the effort and money has been put into acquiring a patent, there may be no place for it in the market. Due to this, some developers shy away from innovation and new ideas as a whole, because the time and money it could take for a software patent with no guarantee for profits. From there, I'd like to talk about some court cases that have shaped software patents over the years. One notable case in 1972 was Gottschalk versus Benson. There, the court said that an algorithm could not be patented, but they did go on to say that the algorithm in this particular case didn't have a specific use, which is why they didn't award a patent. In 2010, the case of Bilski versus Kapos set the precedent for software as an abstract idea that does not meet the older standards for a patent. This case also said that the machine or transformation test is a good way to figure out if software is an invention and can be patented. Then in 2014, in the landmark case of Alice Corporation versus CLS Bank International, the court ruled that abstract ideas will not receive patents. The software in question only used a generic computer to run a business model. The process of using software on a generic computer isn't unique enough to separate software from abstract. Since the Alice ruling, software patents have been harder to get. Numerous cases have gone to court, and many patents have been rejected due to the abstract idea rule. On one hand, the court's ruling for Alice is a sensible approach to resolve disputes about software patents under Section 101 of the Patent Act. One could argue that the Supreme Court was simply cleaning up the mess that had been going on for years in the federal courts, where the courts had failed to reach meaningful consensus on software patent issues. The Alice decision was part of the Supreme Court's increased involvement in intellectual property, and it was a stand to provide clarity and predictability while maintaining consistency with the court's earlier decisions. On the other hand, Alice's abstract test is extremely subjective, and the lack of clarity in the federal courts could be a result of the Supreme Court's intervention of Section 101 as far back as the 1972 Benson case. This brings up another problem. It seems as though the people in the patent office, in general, are simply not qualified to determine whether a particular software invention is patentable or not, leaving it up to the courts to decide whether a patent is valid when the owner tries to assert their rights to it. That means if you're a small company and you infringe on a patent, you likely don't have the resources to fight that patent anyway. I would like to see them throw out this topic altogether and not waste time on court battles and hinder more innovation during that time. This takes me to my second reason as to why software patents should not exist. That is court litigations. In the long run, even the positive aspects of software patents providing an incentive for innovation may be more apparent than real. The existence of a large number of monopolies created by the patent grants reduces the incentives for current innovation because current innovators are subject to constant legal action and licensing demands from earlier patent holders. Ultimately, lawsuits can be a way of shutting down innovation in its early stages and can be intimidating to people trying to experiment in this space. Large U.S. lawsuits resulting in billions of dollars have happened over software patents. From a legal standpoint, you can get a patent for software, but there have been many confusing and conflicting Supreme Court rulings around software patents over the years. And there's been a lack of evidence to suggest that software patents have any positive effect on innovation, and furthermore, the system encourages companies to inhibit competition by blocking innovation. One study that I read about said that in 1 year, American public companies' total profits from patents, excluding pharmaceuticals, was about $4 billion. But the associated litigation costs were about $14 billion. This does not equate to being a good economic boost. In one article, it mentions disputes over software patents are common, expensive, and counterproductive. Their exclusion from the patent system would discourage some software innovations, but the saving of litigation costs over disputed patent rights would more than compensate the economy for that cost. In addition to litigations and settlements, software companies are becoming patent hoarders, spending billions of dollars on accumulating patents. This brings me to the third reason why software patents should not exist. That is patent trolling. This concept is in effect when a company makes money on patent infringement lawsuits. Unlike operation companies that use their patents to produce and sell products, patent trolls acquire patents and do not use those patents in operation. They charge licensing fees to other businesses and individuals that appear to infringe upon a patent that they own. If that company does not comply, the patent troll will threaten a lawsuit. In 2016, IBM earned 8,088 U.S. patents, earning the most grants from the U.S. Patent Office for the 24th year in a row. Big businesses such as IBM, Google, and Oracle are known for gathering many patents in fields considered hot, such as artificial intelligence, to limit the innovation potential of smaller businesses. But it's not only the large companies that are practicing patent trolling. Non-practicing entities do this as well. They are businesses that assert patents through litigation to achieve revenues from alleged infringers without practicing or commercializing the technology covered by the patents they hold. These entities are very effective in their litigations. On average, they've been awarded lawsuit amounts 3 times greater than practicing entities over the last 5 years. One litigation report noted that in 1 year, nearly 4,500 patent cases were filed, and patent trolls were responsible for 2,800 cases, accounting for 63% of the total lawsuits, whereas actual operating companies filed only 1,700 cases. That's nearly double the lawsuits that would have been filed if everyone was just concentrating on innovating instead of generating lawsuits. I think resources could be better put to use in creating new and innovative software advances. Too many patents are given out, making it difficult for developers to create new software due to the possibility of accidental infringement. And many software engineers agree that this impedes their creativity. Overall, patent trolls are known to affect startups and have significant negative impact on operations, which are important for job creation and innovation. And companies with less than $100 million annual revenue represent 2/3 of the unique defendants in patent troll lawsuits. This only confirms that big businesses are drowning out the smaller developing businesses, which is not good for the economy. Overall, there are always gray areas, but I do think a different way of handling software patents could be better for everyone, specifically taking software patents completely out as an option. An alternative option is open source software. The free and open source software community and many companies that use and contribute to open source oppose software patents because they impede and prohibit the distribution of free software. Open source has become very popular because it allows other users to create their own code to add to a program or a piece of technology. Open source software is software which source code is published and made available to the public, enabling anyone to copy, modify, and redistribute the source code without paying royalties or fees. Open source code can evolve through community cooperation. These communities are composed of individual programmers as well as large companies. Some of the individual programmers who start an open source project may end up establishing companies offering products, which is one advocate of taking away the big business mindset and enhance job creation. When a piece of software is free and open, it empowers the user. They themselves are free to do what they wish with the software. The user can modify the software better to suit their needs, improve the design, and share that improvement with other members of the community. Similarly, when the source code is available to the community at large, the user is no longer dependent on a single manufacturer for support should a problem arise. there's an entire community of users available and able to troubleshoot and solve the problem. It is also available to all users, regardless of their financial circumstance, which could greatly increase innovation in the software industry, provided that more people would be talking to each other and exchanging data and ideas. I suggest focusing on real value and address actual problems instead of just trying to acquire software patents. I think the patent process, along with court litigations and patent trolling, are all good reasons to move to open source software. Yes, maybe some companies would make less profit in the long run, but I think there will be more companies created due to this, ultimately creating more jobs in this sector, helping our economy more so instead of the top 1% income earners gaining more profits. I do think it is an uphill battle as money drives many decisions in this country, but I do think if more people work together, we could advance in innovation much quicker to make it better for everyone. In closing, I'm curious to know how many of you felt algorithm patents stifle innovation as our week 5 ethical scenario. I want to thank you for watching my video presentation, and I'd like to hear your opinions on this topic. Thank you and have a nice day.